What if the citizenship you fought years to earn could now be questioned, delayed, or even taken away? I know that sounds extreme, but right now, in 2026, naturalized citizens across America are waking up to policy changes that nobody fully warned them about. And if you or someone you love is on the path to U.S. citizenship or already holds it, you need to watch every single second of this video, because what I'm about to share could directly affect your status, your rights, and your future in this country. Stay with me. By the end of this video, you will understand exactly what has changed, what it means for you, and what you need to do right now to protect yourself. This is Immigration Desk, and we never let you walk into something this important uninformed. Let's start with something that most people get completely wrong. When people think about immigration policy changes, they assume it only affects people who are still waiting, people in the green card line, people on visas, people trying to get in. They think, once I have my citizenship, I'm safe, nobody can touch me. That used to be mostly true, but 2026 is a different era. The Trump administration has moved in directions that even veteran immigration attorneys are calling unprecedented. And naturalized citizens, people who went through the entire legal process, passed the tests, took the oath, are now finding themselves under a level of scrutiny that didn't exist before. So what exactly is happening? Let's break it down carefully, because there are several layers to this and each one matters. The first major shift is what's being called enhanced denaturalization review. Now, denaturalization is not a new concept. It has always existed as a legal mechanism to strip citizenship from people who obtained it through fraud or by concealing crimes. Historically, it was used in extreme cases: war criminals, people who lied about genocide, serious national security threats. The number of denaturalization cases per year was tiny. We're talking about a handful. But in 2026, the Department of Justice has dramatically expanded the scope of what triggers a denaturalization investigation. The net is now much wider, and that's where everyday naturalized citizens are starting to feel the tremors. Think about this for a moment. Imagine you became a citizen 10 years ago. You answered all the questions honestly, at least to the best of your ability. But what if a minor discrepancy on an old immigration form is now being flagged by a new AI-driven review system? What if a social media post is being interpreted in a way you never intended? This is the new reality that immigration attorneys are dealing with daily in 2026. Here's something important you need to understand. And this is one of the most misunderstood facts in immigration law. When you go through the naturalization process, you sign off on a declaration that you disclosed everything truthfully and that you have no hidden history that would have disqualified you. If the government later believes, for any reason, that this declaration was false, they have grounds to begin denaturalization proceedings. In the past, this mechanism was reserved for truly egregious cases. The concern now is that it's being applied much more broadly to situations that feel far less clear-cut. But here's where it gets even more interesting. And this is the part that almost nobody is talking about. The policy changes in 2026 don't just affect people who are already citizens. They affect people who are right now in the naturalization process. The civics test, the background check, the interview, all of it has been restructured. New questions have been added. The background review now goes back further. Social media screening, which was introduced in earlier years, has been expanded significantly. And the standards for what counts as good moral character, which is a legal requirement for naturalization, have been reinterpreted in ways that are catching applicants completely off guard. Let me give you a real-world picture of what this looks like. Someone we'll call Maria, a woman from El Salvador who has lived in the United States for 15 years, has a green card, has never had any legal trouble, has paid her taxes, raised her children here. She recently went to her naturalization interview. She expected it to go smoothly. Instead, she was asked about social media accounts she hadn't used in years. She was asked about distant family members who live in another country. She was asked to explain a gap in her employment history from 8 years ago. Her case has been pending for months with no decision. This is not an isolated story. Immigration Desk has been receiving messages from viewers across the country describing nearly identical experiences. Now let's talk about something that directly connects to the bigger political picture. The Trump administration's 2026 immigration philosophy is built on a concept called merit-based loyalty. The idea, as it's been publicly framed, is that American citizenship should be held to the highest possible standard, not just in the application process, but on an ongoing basis. Critics argue this represents a fundamental shift in how citizenship is conceptualized. Historically, once you were naturalized, you were legally identical to a natural-born citizen in almost every way. The idea that citizenship is something you can lose through administrative review or through expanded denaturalization criteria is being challenged in courts right now. Several cases are already moving through the federal system. And here is the open question that should be on every naturalized citizen's mind. Where does this end? If the threshold for review keeps lowering, if the definitions keep shifting, at what point does legal citizenship become something that feels conditional? Immigration lawyers will tell you, and this is important, that the law still protects you significantly. But the enforcement environment around that law has changed. And in practice, the difference between legal protection and practical safety can be enormous. So what are the new rules you actually need to know? Let's get specific, because this is what you came here for. Rule number 1, if you have been naturalized and you are traveling internationally, pay close attention to your re-entry experience. There are reports of naturalized citizens, particularly those from countries that are currently on travel restriction or heightened scrutiny lists, being subjected to secondary screening upon return to the United States. This is not supposed to happen to citizens at the same level it happens to visa holders, but it is happening. Document everything. Know your rights. You have the right to an attorney if you are being detained. Rule number 2, your naturalization records are more important than ever. Keep certified copies of your naturalization certificate, your N-400 application, your interview notice, and any correspondence with USCIS in a secure place, both physical and digital. If the government ever initiates a review of your case, having complete records of your own is enormously helpful and can significantly speed up the resolution in your favor. Rule number 3. Be aware of the expanded definition of public charge and how it may interact with benefits you or family members have accessed. The public charge rule, which has been tightened in 2026, primarily affects green card applications and certain visa categories. But the philosophical framework behind it is bleeding into naturalization standards. If you used certain public benefits during your green card period, this may be raised at your naturalization interview in ways it previously was not. Rule number 4. Social media is now a serious factor. This cannot be overstated. USCIS and related agencies are actively reviewing public social media profiles as part of background screening. Posts from years ago, connections to certain accounts, groups you may have liked or followed, all of it can come up. This doesn't mean you need to delete your entire digital history, but you should be aware that it exists and that it will be looked at. Rule number 5. If you have any criminal record, no matter how old, no matter how minor, even an arrest that didn't lead to a conviction, consult an immigration attorney before moving forward with any applications or renewals. The 2026 policy environment has zero tolerance for criminal history surprises, and what was overlooked 5 years ago may not be overlooked today. Now, let me address something that comes up in the comments on Immigration Desk all the time. People ask, is all of this legal? Can the government really do this? The honest answer is, it's complicated. Some of what is happening is being done under existing legal authority, stretched to its limits. Some of it is being challenged in court and may ultimately be ruled unconstitutional. The Supreme Court has historically held that denaturalization requires clear and convincing evidence of fraud or illegality. You cannot lose citizenship simply because a new administration dislikes your politics or your background. That protection is real. But legal protection and the lived experience of navigating this system are two different things. And understanding both is exactly why this channel exists. Here's something that gives me genuine hope, though, and I want to make sure I leave you with this. The legal community in the United States is deeply mobilized on these issues. Immigration nonprofits, civil liberties organizations, and thousands of immigration attorneys are working around the clock to track these policy changes, challenge overreach in courts, and provide resources to affected individuals. You are not alone in this. The system has checks. And historically, overreach in immigration enforcement has been met with significant legal pushback that has protected communities. What does this mean practically? It means that the single most powerful thing you can do right now, if you are a naturalized citizen, if you are in the naturalization process, if you have a green card, if you have any stake in this, is to stay informed, stay organized, and know where to turn. Immigration Desk is committed to being that resource for you. Every time a new policy drops, every time a court issues a ruling, every time the landscape shifts, we will be here to explain it in plain language, without panic, without politics, with just the facts and the guidance you need. Before you go, there are two things I want you to do. First, if you have a specific question about how these 2026 changes might affect your personal situation, drop it in the comments below. We read every single comment on Immigration Desk, and we use your questions to guide future videos. You might be asking exactly what thousands of other viewers need answered. Second, if this video helped you understand something that you didn't understand before, share it. Text it to a family member who is going through the naturalization process. Post it in a community group. Forward it to a friend who just got their green card. Because in 2026, being informed is not a luxury. It is protection. Like this video if it was valuable to you. Subscribe to Immigration Desk if you haven't already. We post regular updates on U.S. immigration policy, and trust me, you do not want to miss what's coming next. There are more changes in the pipeline for 2026 that we are already tracking, and our next video is going to cover something that affects green card holders specifically, in a way that most people have no idea is coming. Stay informed, stay protected, and I'll see you in the next one.